very much, Mr. Chairman. Appreciate the time today. We're here. I'm going to give an overview. We're here. This panel to talk about the Group 4 bill for the court officers and probation officers. So I'm joined, and then at the end, if you would provide me, we've just got a couple other bills I'd like to just touch on. Pretty great. So I'm joined today. I think this is the first time on this particular issue that management and the union have appeared together. And I'm joined today very happily and proudly to sit with Jeff Morrow, the Director of Security for the trial court, and also Court Officer Mark Hurley. We would have liked to have filled the room with court officers and probation officers, but it's hard during the day. They're all doing a very important job, so we're here on their behalf today. So
you get the right panel.
So we'd like to turn it over to Jeff, maybe to start.
Thank you. Chairman, members of the committee, it's a pleasure to be here, and it's a pleasure to sit side by side with Nate on this issue. I'd like to thank you for the opportunity to speak about House Bill 2285, an act relative to defining employees classified in Group 4. As has been said, my name is Jeff Morrow. I'm the Director of Security for the trial court. I've been the Director of Security since September of 2013. Previous to that, I served as a special agent with the Naval Investigative Service, Naval Criminal Investigative Service, for over 31 years. It's great to be back in Massachusetts, and it's great to be back home. I have submitted written testimony on this issue, but would like just to take a few moments to summarize those remarks. House Bill 2285 refers to both officers of the probation service and court officers of the trial court. As the Director of Security for the trial court, I speak to you today only about how this bill would impact court officers and court security. I have, however, spoken to the Commissioner of Probation concerning this legislation. The Commissioner asked me to advise you that he could not be here today, but is interested in further exploring with you the application of Group 4 retirement benefits for probation officers. The mission of the Massachusetts Trial Court Security Department is to provide a safe and secure environment for the administration of justice in the Commonwealth courts. Daily, court officers assist in the process of justice by ensuring order in the state's courthouses. Present in courtrooms, at courthouse entrances, and in the lockup facilities, court officers safeguard the buildings, the grounds, and the people who work in and visit the courts. By their very nature, courthouse operations and the events connected to judicial proceedings entail a heightened degree of risk. Every business day, over 4,000 individuals enter Commonwealth courthouses. The judicial process involves a large number of citizens, many of whom may be disgruntled, angry, or emotionally overwhelmed. Many are accused or have been convicted of serious and violent crimes. Massachusetts court officers are members of the Group 2 retirement program. The role of the court officer is one of a public safety officer. Presently at the trial court, there is an initiative underway to increase the professionalism and capability of court officers to meet today's court security threats. To help accomplish this, the trial court has fully implemented the court officer hiring and promotion reforms mandated in 2011 by court reform legislation. Supplementing merit-based hiring and promotion practices, the Security Department of the trial court has implemented an aggressive training program that includes a revised basic training academy consisting of over 300 hours of court security-related instruction and mandatory in-service training to update the skills of existing officers. To validate the comprehensive and progressive nature of this training, the Security Department is pursuing national accreditation for its training program through the Commission on Accreditation of Law Enforcement Agencies, or CALEA. Attainment of this goal, expected in 2016, will bring with it the distinction that the training that Massachusetts court officers receive is among the best nationally in the area of court security. To continue the professionalization of the trial court security department, it is essential that the department have at its disposal programs, tools, and legislative support needed. As many have recognized, including the Task Force on Hiring in the judicial branch, led by former Attorney General Scott Harshbarger, the job of a court officer contains a very real physical aspect, but has no mandatory retirement age. The care and custody of prisoners in particular places court officers in close contact with accused and convicted criminals. The ability to physically restrain, transport, subdue, or pursue a non-compliant or combative prisoner are fundamental and routine functions of a court officer. Courthouse disruptions and assaults are not uncommon, and it's a court officer's responsibility to physically intervene to protect court users and to apprehend perpetrators. Like others in the public safety profession, court officers must be physically capable of acting as an emergency first responder when incidents and medical emergencies take place in a courthouse. To carry out these duties effectively, court officers must possess an adequate level of physical strength and endurance. The provisions of Group 4 retirement are seen as a valuable human resource management tool to help achieve a workforce that has the physical readiness to meet the sometimes rigorous requirements of a court officer position. As the trial court moves to improve court officer physical readiness, the enactment of Group 4 would undoubtedly assist in that goal and would help the ongoing effort to professionalize the court officer workforce begun by this legislature in its 2011 reforms. I ask you to consider this and continue to assist the judiciary in its ongoing efforts to increase modernization and professionalism within the trial court. Thank you.
Thank you. And on behalf of the union, I'd just like to say this is obviously not the first time this bill's been through the committee. We've worked very hard on this for a good number of years. The bill's been vetted by committee in the past. We've had PERAC reports done on this issue. It's been out of committee favorably. The court officers and probation officers remain the one link in the public safety chain that do not have Group 4. Basically dealing with the same stresses, both emotional and physical, of the jobs. And as we've worked on these classification issues over the last several years with the Blue Ribbon Panel, and then the last two commissions, the last one specifically to look at pension classification, the one issue was where is that bright line, to determine who should have Group 4, who should have Group 2, who should have Group 1. And I think consistently our position has been that you look at the job overall from 10,000 feet, there's a limited time and ability to be able to endure that stress, to be able to endure that physical and emotional stress on a day in and day out basis. So I think it's very clear that they're a critical component of the public safety link, and the delivery of justice. And in those situations, in the courtrooms, when a probation officer is out in the field, they're very, very emotional. They can be volatile situations. And it takes a split second for something to happen. And they carry that emotional stress every single day, and that wears on. So we're just asking for equity here with the rest of the public safety community. Mark is here today. I just wanted to offer him to say a few words, but I think he's all set for today. And love to get your consideration on that.
Thank you very much. I spent some time in Brockton District and Brockton Superior and function in the courtroom and in particular in lockup is much like a correctional officer.
Very much, yes.
Excellent work on the progress that you made.
Thank you.
It's very good for the Commonwealth.